Hello everyone, welcome to my channel. We have already discussed the primary sources of Indian law in my previous video. In this video, we will focus on the secondary sources. So, secondary sources can be categorized into two. The first, justice, equity and good consent, and second, the sources of English law, under which comes the common law, law merchant, principle of equity and statute law. Looking forward to justice, equity, and good conscience, the concept was introduced by Impe's regulation of 1781. In personal law disputes, the court are required to apply the personal law of the defendant if the point at issue is not covered by any statute or custom. In the absence of any of statutory law or custom or personal law, the Indian courts apply to the decision of a case which is known as justice, equity and good conscience, which means the rule of English law in so far as they are applicable to the Indian society and its circumstances. The ancient Hindu law had its own versions of the doctrine of justice, equity and good conscience. In its modern version, justice, equity and good conscience as a source of law owes its origin to the beginning of the British administration of justice in India. The charters of several high courts established by the British government directed that when the law was silent on a matter, they should decide the cases in accordance with justice, equity and good conscience. Justice, equity and good conscience have been generally interpreted to mean the rules of English law on an analogous matter as modified to suit the Indian conditions and circumstances. The Supreme Court has stated that it is now well established that in the absence of any rule of Hindu law, the courts have the authority to decide cases on the basis of justice, equity, and good conscience, unless in doing so the decision would be repugnant to or inconsistent with any of the doctrine or theory of Hindu law. Now, moving forward, the sources of English law. Its chief sources are the common law, law merchant, principle of equity, and statute law. So, the common law in this context is name given to those principles of law evolved by the judges in making decisions on cases that are brought before them. These principles have been built up over many years so as to form a complete statement of law in particular areas. Thus, common law denotes that body of legal rules, the primary sources of which were general, immemorial customs, judicial decisions, and textbooks on jurisprudence. Common law is unwritten law of England, which is common to the whole of realm. The second source of English law is the law merchant. The law merchant is the most important source of the mercantile law. It means those customs and usages which are binding on traders in their dealings with each other. But before a custom can have a binding force of law, it must be shown that a custom is ancient, general, as well as commands universal compliance. In all other cases, a custom have to be proven by the party claiming it. Another is the principle of equity. Equity is a body of rules, the primary sources of which was neither custom nor written law, but the imperative dictates of consciousness, and which had been set forth and developed in the courts of chancery in England. The procedure of common law courts was very technical and dilatory. Action at common law could be commenced by first obtaining a writ or a process. The writs were limited in a number, and unless a person was able to bring his case within one of those writs, no action could lie at the common law. In some cases, there was no remedy or inadequate remedy at the common law. The king is considered as the fountainhead of justice. When people were dissatisfied with the decision of common law court, they could always file a mercy petition with the king in council. Then the king would refer these petitions to his chancellor. The chancellor, who was usually a bishop, would dispose of these petitions not according to the rigid letter of law, but according to his own dictates of common sense, natural justice, and good conscience. The law so administered by the Chancellor came to be known as equity, and such courts as equity courts. These equity courts acted on a number of maxims. The most common maxims are: he who seeks equity must do equity, and he who comes to equity must come with clean hands. Some of the important principles and remedies developed by equity courts are recognition of the right of beneficiary to trust property, remedy of specific performance of contract, equity of redemption in case of mortgages, and etc. The last source of English law is the statute law, which is that portion of law which is derived from the legislation or enactment of the parliament or the subordinate and delegated legislative bodies. It is now a very important source of mercantile law as well. A written or statute law overrides an unwritten law, that is, both common law and equity. Some of the enactments in the domain of mercantile law are the Partnership Act, the Sale of Goods Act, Bankruptcy Act, and others. So this was all the secondary sources of Indian law. If you like my video, please do subscribe to my channel and don't forget to press the bell icon. This will motivate me and so that I'll keep making such videos. Thank you for watching.